Hi, this is Professor Pope, and this is the second video for the beginning of the health law seminar. In the last video, we talked about selecting your topic. In this video, we're going to talk about selecting your thesis. So we're going to be moving from topic to thesis. So let's assume you watched the last video and you did everything that I said, and you have successfully identified a topic, some issue in health law. Great. But what exactly is it that you are going to say about that topic, right? What is your contribution? What is your position? Now, legal literature almost always takes a normative thesis, right? If you pull off 10 law review articles off a shelf or off Westlaw, right, they're almost all going to have a normative thesis. For example, right, the court should have decided it this way, or the court should decide this case this way, or the legislature ought to amend this law to do this, do such and such, right? So it's always a recommendation to a judge or to a legislature or to, perhaps, parties on how they should conduct themselves to avoid, violating the law. But it's always advice. This is what you should do to comply with the law, to change the law, to interpret the law. Now, that's the normal, usual type of thesis. There are other valid types of thesis, absolutely, totally welcome in this seminar as well. So, for example, this might be a descriptive thesis where you're literally just comparing how jurisdiction X handles something to how jurisdiction Y handles the same issue. Or maybe it's a definitional thesis. For example, maybe there's a key word in a regulation and your paper is about what that term means or what it covers. So, but the point is, you have to have a unique contribution. So what is it? What are the criteria for identifying what's a good message? What's a good thesis? What's a good claim that you want to make, assert, defend, justify? Well, first it should be original, right? Now, many of you will not publish your papers. It would be great if you do, but let's assume that you will, or let's at least hypothesize that you will, such that it is going to be out there, and well, on that assumption, you'd want it to be original. You wouldn't want to say the same thing that a bunch of other people have already said, because then you're not adding anything. So you can look to, current events, trends, controversies, new laws, new regulations, new court decisions that have created unanswered questions, have created debates, conflicts, or unintended consequences. So one thing that comes up in health law, is that we're always inventing new technologies, right? We were able to do things that we previously weren't able to do, and that leaves some uncertainty as to how the old law applies to the new technology, right? So we have, for example, mobile health apps, and how does that apply in terms of device law, in terms of, licensing, in terms of patient privacy. We're always inventing new technology in terms of we're able to 3D print human organs. So there's always questions that are created by the advance of technology. That's not at all the only way in which gaps and uncertainties are created in the law, but it's definitely a big way. Now, just because other people have written about your topic, and just because other people have written defending the same claim that you want to defend within that topic, doesn't mean that you're preempted, because maybe you, even though you're writing about the same topic and you're making the same claim about that topic, maybe you have different arguments to support that claim, or maybe you have different evidence to support that claim. So, or maybe you just think you can make it better, more eloquent. Your topic should be interesting. So you don't want to say something that's already well settled. That wouldn't be original. But even if it's original, it should be interesting. So perhaps you wouldn't want to write about something that's not super relevant to potential readers. So if it was science fiction, so in other words, you're hypothesizing a world in which there's a health law issue that would affect astronauts living on Mars. Maybe that's a little bit too distant of a potential issue that doesn't really affect anybody, or won't affect anybody for a long time. So, suggest a change in the law, predict a change in the law, criticize a key article, or criticize a key judicial opinion, or synthesize law that's not really yet been drawn together. And there's other approaches that you can take. Again, I would recommend perhaps looking at the guides and tips that I've posted in PDF, the number of articles on identifying a good thesis or claim, as well as the Volokh or the Fagins and Falk books. The first deadline in the health law seminar is January 27th. And that deadline, what I've said is in 400 to 500 words, describe the issue that you plan to address. So that would be the topic. And then what you want to say about it, and that would be the claim or the thesis. So there's a topic, and then there's your claim or thesis about that topic. Now, you're not stuck. You can change it. Changing probably isn't very good idea, because then you're starting over, and there's a inefficiency and a time factor. But it can evolve a little bit. And that's perfectly okay. But knowing that you're not absolutely locked in, at least state what it is now. And then this is just 5% of your course grade, largely based on have you submitted it or have you not submitted it. Now, you're only submitting 500 words at this stage, right? So that's all you're giving to me. But for yourself, you should aim to go beyond that and really aim to jump in and start writing your paper. And that's my final piece of advice here, which is to start writing now. Don't sequence the research and the writing. So you wrote the thesis statement, and you think, well, I don't know how I'm going to support this. I don't know how I'm going to defend it. I need to read a whole bunch of stuff first, and then I'll start writing. Don't do that. Read a little bit of stuff, then start writing, and then go back and read some more stuff. So go back and forth between research and writing. Don't sequence all the research and then start writing only once that's completed. So your thesis statement is a proposition, right, that you will defend. But do an early draft now of how it is that you will support and defend it, or at least how you think you will support and defend it. I mean, and I don't need this. This doesn't have to be part of what you submit on January 27th, but start getting that out at least in a rough way now. And then as you read more, you can continually refine that and build it out. Typically, and this is by no means mandatory, this is just a totally suggested template. Very, very rough. I mean, you wouldn't really literally follow this in any case. But normally a law review article will have an introduction, and then it describes a problem, right? Something that's happening in the world, right? People aren't getting a certain type of treatment, or people are treated disparately, or people are getting in trouble for something they shouldn't be getting in trouble for. That's just something that's happening, right? So that's purely a scientific, medical, demographic, sociological point. Then you talk about, look, this is how the law handles this now. This is what the current law is. And normally, there's a problem with that law. That's why there's there's some sort of problem, right? The law isn't handling it as well as it could. So then the next section is, this is how we could change the law so it could handle the problem or eliminate the problem. And then there's a conclusion.